The court is fully aware of the anti-majoritarian character of its work, and in many instances, it will try to avoid or minimize the occasions for striking down decisions made by the politically accounted branches. It is worried about this question of legitimacy. The court is also fully aware of its lack of competence to oversee and monitor broad-based policy choices in the society. For example, when we talk about such things as equal protection scrutiny, you'll see that the court is ordinarily eager to defer to the legislative branch in terms of what decisions are sensible in terms of economics and social regulation. The court is also fully aware that as a court, its work has to be based on principles that can be articulated, that will give guidance and offer predictability in the law. The court is concerned lest its rulings open the floodgates to a rush of cases that the court is really unable to handle. The court worries, in other words, about its ultimate effectiveness. If the court can't identify an administrable rule to apply in an area, it sometimes may leave the area, constitutionally speaking, unregulated. For example, you might see something of this when we talk about court-enforced limits on federal powers that affect the states. But in general, the main point is, you should be mindful before we begin to look at particular cases that the court is very, very self-conscious about the nature of its role in our governmental scheme, and that this self-conscious view can and will influence outcomes in particular cases. Okay, now we'll look at the circumstances under which federal courts can act and the kind of cases that they can hear. Because if federal courts don't have any power to act, then obviously they can't exercise the power of judicial review. Now, federal courts, like the federal government in general, is limited to those powers conferred upon them by the Constitution. And there are two major kinds of limitations affecting when and under what circumstances federal courts can act. The first is jurisdiction, and by that we mean the power to hear certain kinds of cases. We'll look at three main limitations on federal courts' jurisdiction. We'll look at Article 3, which is the main source of federal judicial power in the Constitution, and congressional controls of jurisdiction under Article 3. Then we'll look at the 11th Amendment, and finally we'll look at the doctrine of abstention. The second major limit on when federal courts can act arises under the heading of justiciability. Article 3 limits courts to hearing and deciding, quote, cases and controversies, unquote. Matters coming to a federal court must have the right ingredients or characteristics that make it something a court will actually decide. Justiciability issues, as you'll see, include such things as standing, ripeness, political questions. Okay, first looking at jurisdiction. We will start by looking at Article 3. Article 3 identifies the potential jurisdiction of the federal courts. That is the kind of cases that federal courts can hear. And what you need to know is that there are certain categories of cases, and only those cases, that federal courts can hear. Among them are two that you're very, very familiar with. One is the so-called arising under jurisdiction, or federal subject matter jurisdiction. Any case that raises a matter of federal law, whether it be under the Constitution, a federal treaty, a statute, a regulation, can be heard in federal court. The second very familiar category of case that the court can hear, the federal courts can hear, are cases involving diversity of citizenship jurisdiction. That is where the suit involves citizens from different states. Now, in addition to these well-known categories, there are some other categories listed in Article 3, and I'll just mention them. Admiralty and maritime jurisdiction, cases involving representatives of foreign governments such as ambassadors, cases in which the United States is a party, and also cases where there's a fight or a dispute between two states. Now, the point about all of this is that unless your case falls within one of these categories, you may not go into federal court. Now, in addition to setting out the general categories that federal courts can hear, Article 3 also divides the jurisdiction of the federal courts between lower federal courts and the Supreme Court. And the way it works is this. The Supreme Court is created by Article 3. It exists by virtue of the Constitution. But Congress is given power to create, or not create, presumably, lower federal courts, though from the very beginning Congress always created such lower federal courts. Let's talk about the jurisdiction of the Supreme Court. Article 3 divides the jurisdiction of the Supreme Court into original or trial-type jurisdiction and appellate jurisdiction, the one that we know best. Now, what you need to know about this first is that the original jurisdiction of the Supreme Court is conferred by the Constitution itself, and it extends to really two kinds of cases. One involving representatives of foreign governments, and the other cases in which a state is a party. In those kinds of cases, you start your case originally in the Supreme Court of the United States as the trial court. Now, the most prominent current case as part of the original jurisdiction of the Supreme Court is a fight between New Jersey and New York over who owns Ellis Island, where the Statue of Liberty is located. That's within the original jurisdiction of the Supreme Court. Now, what's noteworthy about the original jurisdiction is that that jurisdiction is conferred by the Constitution itself. Congress may neither add to nor subtract from that jurisdiction. Now, Congress can allow lower federal courts to have concurrent jurisdiction with the Supreme Court in these kinds of cases, but the principal point is that Congress may not add to the original jurisdiction of the Supreme Court or take it away, because it is conferred directly by the Constitution. Now, all other jurisdiction of the Supreme Court is appellate. The court hears cases coming from somewhere else and exercises a review authority over them. And that is, as I've said, the kind of jurisdiction with which we are most familiar. So let's look at several questions concerning the Supreme Court's appellate jurisdiction. First, procedurally, how does the Supreme Court take cases as part of its appellate jurisdiction? Well, the typical way is that parties ask the Supreme Court if they would please review their case, and they file a writ of certiorari. 99.9% of the cases going to the Supreme Court go by writ of certiorari. Now, writ of certiorari is discretionary. It's entirely discretionary. The Supreme Court does not have to review any case by writ of certiorari unless it decides it wants to. And what the court does is follow the so-called rule of 4. If at least 4 justices want to hear a case, they will grant the writ. And as you may know, the court has become quite sparing in recent terms about how many cases it will actually hear, and the numbers have gone down rather dramatically. The court used to hear well over 100 cases a term, but in the last several years it has dropped its docket to well below 100 cases. Thousands and thousands of writs are filed every year, but the justices, as a relative matter, take a few cases. Now, some have said they're doing less, but not necessarily doing better, but in any event, as a formal matter, it's up to the justices how many cases they're going to hear and whether they'll hear your case. And the denial of a writ is not a decision on the merits. It simply means that the court does not want to hear your case. Now, a second question about the Supreme Court's appellate jurisdiction is what limits exist on the Supreme Court's review of cases coming from state courts. Now, as I said, the Supreme Court does have review authority over state court cases. That was established in Martin v. Hunter's lessee. But because of matters of jurisdiction, but also matters of federalism, there are some further refinements we have to make to understand how this review authority is exerted over state court judgments. In terms of the Supreme Court looking at cases in the federal system, of course, you know it goes first to a federal district court, then the Court of Appeals, and then you file your writ of certiorari and the court takes the case or not. But it's a little bit more complicated when a case involving an issue of constitutional law originates first in the state courts. Now, there's a general proposition that comes out of Martin v. Hunter's lessee, as I said, that the court does have constitutional